Okay, it's 9 o'clock, so we're ready to begin. I said good morning. Welcome to another oral argument session of the Fifth District Court of Appeal by Zoom in light of our pandemic. I am Brian Lambert. Will be presiding today. On the panel with me is Judge Jim Edwards, and we are pleased to have an associate judge sitting with us for Judge Wallace this morning. It's Judge Brian Duckworth, who is, I believe, a county court judge from Orange County. I think it's his first time. Is this your first time with us?
It is. It is. Thank you very much.
Well, we're pleased to have you with us and helping us today and on Wednesday for our oral arguments as well. All right. Our first case on the docket is 21-629, April Lee Smith versus State of Florida. It's a criminal appeal. Each side will have 20 minutes. We are being watched. Well, we are watchable on Zoom on YouTube. So whether anybody's watching us, I guess that's another story. So just keep that in mind when you're making your arguments. If you have any type of electronic devices, please just turn them either off or in the mute position so it doesn't distract either the other counsel or the panel during the argument. Again, there's 20 minutes. The appellant, you see there's a clock. It's in my upper left corner, whether it's there with you as well, I'm not sure, but you can see the clock. Typically, we reserve 5 minutes for a rebuttal for the appellant. Counsel, if you would like some other time, let us know. And the marshal who is keeping track of the clock for us today will note that. That being said, if you're all ready, counsel, let's begin.
Thank you. May it please the court, Andrea Fant on behalf of Ms. April Smith, and I would ask for 5 minutes reserved for rebuttal.
Very well.
So the standard of review in this particular case is abuse of discretion and reversible error. And that's when we're dealing with the issue of whether the lower court erred in denying defense's proposed jury instructions. I would reference the case King v. State, which is a 5th DCA case. This court held that the defendant was entitled to jury instructions on the theory of his defense if there was any evidence in the record to support it. Courts have also held that because the standard is only if there's any evidence, that the lower court has a very narrow discretion in that regard. In our particular case, Ms. Smith actually took the stand. She testified on her own behalf that she was in downtown Melbourne. She had a designated driver who drove her vehicle to Palm Bay Police Department. There was an argument that ensued en route. And because she knew that this designated driver was unfamiliar with the area, she directed him specifically to Palm Bay Police Department. He went into a restricted area, and once they were in the restricted area, she exited the vehicle. She came in contact with Officer Alafi, and Officer Alafi questioned her and asked her, had you been drinking? Before he instructed her to get in the vehicle and drive over to the city hall where there was a parking lot because he didn't want her in the restricted area. While they were conversing, the guy who was driving her vehicle, Brian, he switched seats. And Ms. Smith testified on the stand. She believed he did that because his license was in fact suspended and he was trying to maybe escape prosecution. So
my biggest question really is, what was she being prosecuted for at the trial? Was she being prosecuted into the restricted area or from driving from the police department restricted lot to City Hall? I mean, when you look at the opening statements, you look at the testimony, you look at the closing arguments, it seems like the state was focused on the fact of her driving in, which had, of course, contrary evidence, conflicting evidence to what you just mentioned.
She was being prosecuted for a DUI, and she was also being prosecuted for driving while license suspended. So the argument can't be made that, well, she was only guilty of a DUI because she allegedly drove from downtown Melbourne to the Palm Bay Police Department. But when she drove from the police department to City Hall, then now that's not a DUI. Their argument was that she was driving while her normal faculties were impaired. And to isolate it and only use their version of the events, that's not what the law indicates here. The law indicates if there is any evidence to support the jury instruction that it should be given.
But the entrapment defense would only apply to her conduct in driving from the police department to the city hall. You agree with that, don't you?
Correct, because that's our version of the facts. Our version is that she was only placed behind the vehicle, behind the wheel of the vehicle, when she was instructed to drive from the police department to City Hall.
Well, I understand that, but from the state's perspective, if a person is perhaps committing 2 or 3 of the same criminal acts at different times, different places, is there some case you know of that says the state must charge them with all 2, all 3 of the same crimes, or can they just choose one and prosecute and go forward to trial on just one of 2 or 3?
As far as case law that says that they have to, no, I'm not aware of any case law that says that they must. But if their argument is that she's driving while impaired, then I would submit to you that it didn't just end with the police department, because then there was additional evidence put on that she had actually driven from Palm Bay Police Department to City Hall.
Who put that evidence on?
Well, that was both, because we put it on, but Officer Alafi testified that he did in fact instruct her to drive over to City Hall. So
I think he
she
said
was
he directed
driving.
her. I think he said he directed her there. I don't think he told her to drive in terms of his own direct testimony, did he?
I believe he told her, he instructed her to drive from Palm Bay to the City Hall because she was in a restricted area. That's not just evidence that we placed on as a defense. That was also evidence that came out with the state.
On direct testimony.
Yeah, I believe it was.
As to the first drive, let's call it first drive versus second drive, the drive into the restricted area. I understand your position is, or your client's testimony is, I was not the one driving, it was the other guy, right?
Correct.
Okay, so as to your entrapment defense, that would not be applicable as to the first drive. Would you agree with that?
I would agree with that because our version is that she wasn't driving.
I get that. Entrapment is, yes, I did it, but you guys did something that caused me to commit this crime that I otherwise would not have committed.
That's correct.
All right. So if the position of the defendant in her testimony is, I wasn't driving, then I can't be entrapped. So the entrapment is to drive number 2, right?
It is.
Okay.
Because otherwise
as Judge Edwards is saying, though, if the state says, look, we're just prosecuting on the first drive, we're not prosecuting on the second drive, because that's somewhat disingenuous for the state for a police officer to say, okay, I want you to drive from here to there. Now I'm going to arrest you for DUI driving from here to there. And it seems like, you're reading the record, it seems like the state understood that, so they didn't prosecute on that second drive, for lack of a better term. So if the state was not prosecuting on the second drive, then wouldn't you agree that the trial judge correctly did not read the entrapment instruction as to the first drive, right? Doesn't that logically make sense?
No, Your Honor. The reason why I disagree with that is because I don't agree that they stopped it at the Palm Bay Police Department.
I know you don't agree with it, but since I get to make up my questions, that logically makes sense though, right? If you don't think that's what happened, but under my hypothetical, the answer would be yes, right?
Under the hypothetical, if they stopped it at Palm Bay Police Department.
Right. If your lady had never driven the second drive out of the police station to the City Hall, she had never driven that, and she just said, I'm not driving, and they prosecuted her for the DUI, then we wouldn't be talking about entrapment, right?
That's correct.
Okay.
That's correct. Because our argument is that she wasn't driving the first time.
Right.
So she wasn't
She didn't commit a crime.
Correct. She had a designated driver. So the issue rises because they did instruct her to drive over to the city hall, and that was the only time that she drove.
But doesn't the officer testify differently as to that he saw her drive number one?
He does, but that's the mistake that the lower court made. The lower court said that she was denying the instructions because there was a conflict in the evidence. That's not what the law dictates. The law doesn't say that if there's a conflict in the evidence, you deny the instructions. It says quite the opposite. It says if there is any evidence to support the defense's theory, they're entitled to it.
Right, but even if the trial judge used the wrong rationale, really the heart of this whole case, as I see it, is there's evidence that says your lady was drive number one. Whether you like that evidence or not, or whether your client disagrees with it, that's evidence that's heard by the jury, right?
Correct.
Okay. So at that point, your position as to drive one is there is no entrapment. There can't be because the officer's wrong. And then you wouldn't make an argument for an entrapment instruction as to drive one.
Right, but I would just submit to the court that if you're doing that, you're now weighing the evidence. You're now saying, based off of the state's case and their version of events, this is what was presented. So this is.
It's not a weighing of the evidence. They're accepting your evidence. If you accept your evidence, you can't be entrapped as a matter of law, is what I think you're agreeing to. That if I wasn't the driver, I can't have been entrapped to commit a DUI because I wasn't doing the D as the DUI.
For the first drive, that's correct.
Right. Okay. So it's not a weighing of the evidence. It's not a defense to the argument. I mean, if there was simply a drive and your lady testified, I wasn't driving, it was the other guy, and the officer said, no, she was driving, I saw her, then that would go to the jury for a factual determination as to whether the state proved the crime beyond a reasonable doubt. And there wouldn't be an issue of entrapment. Isn't that a fair analysis? How can that not be a fair analysis?
I just believe that if you only isolate the first drive and you eliminate the second drive, and you eliminate this defense.
What if the state gets up and says, okay, let's be very clear, ladies and gentlemen of the jury, as we start this case, you may hear about 2 drives. We are not saying that she did anything on the second. We're not prosecuting her on that. That's not the charge. We're here about the drive to the restricted area. That's the only thing you need to focus on. And if we didn't prove that she was a DUI on that first drive, bring back a not guilty because we didn't prove it. If the state stood up and said that, wouldn't that end our discussion today, or shouldn't that?
Well, if that's what the state was doing, then there would have been pretrial motions, because then I would have argued that nothing about the second drive should have come in the beginning. If they're now changing their argument to say it's only about the first drive and it's nothing about the second drive, then that shouldn't have come in at all. That wasn't the case. It all came in, and our position from the defense's position was that she drove only because she was instructed to do so. So now you can't disregard that, because that is our defense. That is what we are alleging. That's the only time she drove.
Ms. Fant, Judge Duckworth, I have a question. I see in the record that your client was charged by way of information with the DUI and the driving with suspended license. And the information doesn't appear to differentiate or mention 2 separate drives. Is that significant at all?
I don't believe so, because it came up during the trial. Both came up during the trial. Both drives came up during the trial.
Well, again, I'm looking at your brief, which is where I got the statement originally and went and confirmed it. The direct testimony from Officer Alafi was he engaged in a brief conversation with Ms. Smith at the police department restricted lot, and then he quote unquote directed her to City Hall. And there were anytime there was direct testimony from the officers, it was she was outside the fence. She had been directed to City Hall. There was nothing, and during your rebuttal, if you have time to find it, I would really want to know if there was anywhere where the state on direct with any of its witnesses talked about she drove from the parking lot at police department to City Hall. That to me is important because the closing argument certainly doesn't talk about her driving from the police department. The opening argument doesn't talk about her driving from the police department, other than in response to the entrapment argument that y'all made. So if you have a chance during the time between your initial and rebuttal argument to find that, it would be very helpful to me.
Okay, thank you. And I'll reserve my remaining time if there's no further questions for rebuttal.
Okay, thank you, counsel.
Thank you.
Good morning again. May it please the court. My name is Robert Bradford and I represent the state of Florida in this matter. As the court and opposing counsel were discussing, the state's theory of this case is exactly as described by Judge Lambert. That being that the appellant drove into the restricted parking lot at the Palm Bay Police Department and did so with an unlawful blood alcohol level. Specifically, the state offered evidence, again, as noted by Judge Edwards, that Officer Alalfi observed her driving into the lot and directed her to the City Hall lot subsequently to the conversation that they had, which I believe the testimony was his testimony was that he was never less than 10 feet or about maybe as much as 15 feet away from her in the restricted lot. The state also argued to the jury during its summation that she drove into the restricted area, i.e. within the state, and that she did so with an unlawful blood alcohol level. The state rested its case in chief and concluded its summation without advising or arguing that the appellant drove out of the restricted area with an unlawful blood alcohol level. There was some discussion in Ms. Vance's argument that Officer Alalfi said that he asked her to drive to the City Hall lot on his direct testimony. That simply is not the case. I went through the record with a fine tooth comb. He said on direct examination, I directed her to the City Hall lot. He was then cross-examined and said, didn't you tell her to drive her car to the City Hall lot? And he admitted he did do that, but that was on cross-examination. The state didn't do anything to bring out the fact that she drove out of the restricted area, only that she drove in. When defense counsel then expanded both the facts at issue and the time period at issue by cross-examining Officer Alalfi on having her drive to the other lot. And then she testified that she did not drive in, that she drove out. But as I think Judge Lambert mentioned, when, if that was it, if it stops there before he has her drive out and there's none of that evidence before the jury, it's just your classic DUI case. Were you driving? Were you impaired? And in this case, she had an unlawful blood alcohol level 0.142, 0.148, I believe. But it was a classic question of fact. And it was the defense's actions in the cross-examination and in offering the testimony that created this additional possible entrapment defense by offering those entrapment facts. The state never argued the entrapment facts. The state only argued the first drive and the driving into. Therefore, because the state didn't use that, the judge did not abuse his discretion in denying the defense, the instruction. If there are no questions, then I'll forego the rest of my time and rely on the answer brief for the remaining argument. Thank you.
Thank you, counsel. All right, Ms. Fant, you have 6:20 according to the clock for rebuttal.
Yes, so I would just add that we're entitled to instructions that regarding our defense. And if that's our defense, that she only drove from Palm Bay Police Department to the City Hall, we were entitled to the instructions regarding that because that was evidence that came out during the trial.
But that's not the crime that the state's prosecuting, is it?
They're prosecuting a DUI. They prosecuted her driving while her license was suspended. It came out that she did drive from Palm Bay to City Hall, from Palm Bay Police Department to City Hall.
Did it come out, Mr. Bradford said it came out during cross-examination when the police officer was asked that question. Is that accurate? Is that an accurate recitation from the record?
When I just reviewed the record again, the state did ask, did you direct her to City Hall? I would argue if an officer is directing you to do something, you wouldn't just say no. And I would imagine if she said no, she'd be charged with another crime. So if the officer is telling her, move your vehicle from this restricted area, directing her to City Hall, then she's required to do that. And she did as she was instructed. So I would just offer that to this court, or submit to this court, that it was our theory, that was our defense, that was evidence that came out during the trial, and we were at least entitled to the instruction. Whether or not the jury would have believed we proved entrapment, or whether the judge believed we proved entrapment, was not to be considered in making that determination. And the court made a determination based off of a conflict in the evidence.
Well, then let me ask, so if the instruction was given, would it not have been fine-tuned to say this only applies to the second drive and it has nothing to do with the first drive? And therefore, even whether it was given or not, it doesn't really matter because it has absolutely nothing to do with drive number one? Right? It's not a defense. You've admitted, rightfully so, it's not a defense to the first drive. And so if you had gotten the entrapment argument that you've requested, it wouldn't apply broad base. It would apply to just leaving the police station, going to City Hall. And, then the state, I guess, will say, we're talking about two separate drives. And even if you find entrapment as to number two, it has absolutely nothing to do with the first one. Is that how it would be envisioned?
And then our rebuttal would be, the first one didn't happen. The first one didn't happen. She didn't drive.
The jury obviously didn't believe that version. If they believed she wasn't driving and the state didn't really argue the second drive, then, they wouldn't have convicted her. And really and truly, the state, looking at its closing argument, the only time the state mentions at all the second drive is in response to defense arguments that I didn't drive the first drive. I only drove the second drive because the police officer told me to. I mean, it's fair for them to respond to your argument, but in terms of, if the jury had believed she was not the driver, which is what you keep saying, they wouldn't have convicted her on the charge that they went forward with, would they?
But we don't know how it could have turned out had they been given the actual instruction.
But the entrapment defense does not apply to drive number one. We've all agreed on that. If it didn't apply to drive number one, and that's really what the state's focus was, if they believe she wasn't the driver, they would have acquitted her.
Respectfully, I would disagree. Because we don't know where their deliberations would have gone had they been given the actual instructions. We don't know how that would have changed the deliberations.
We have to assume, Judge Lambert and you had a conversation about how it would have had to be fine-tuned, that entrapment would only apply to number two. And the law is clear that we have to assume jurors follow their instructions, and they would have only applied that to drive number two. As to drive number one, if they believed she was not the driver, they would have acquitted.
I agree that they can only follow the law, but I don't agree that they would have had to isolate and compartmentalize their deliberations into two parts. We don't know how they deliberated, and they could have deliberated both drives at the same time. They could have gone back and forth about that. I don't agree that they would have had to have talked about drive number one and then talk about drive number two. They could have talked about it all together and how they felt about both drives. And given the instructions, they would have been given law on how they are to deal with the fact that our defense was that she only drove once. And the one time she drove, it was because she was instructed to do so.
Okay.
So I would just argue that even if there's a conflict in the evidence, that's not what the law mandates. It mandates that if there is any evidence to support the defense's theory, they should have been given the instructions. And we believe that the lower court erred. It's a narrow discretion. She erred in that and denying us even the instructions to present it to the jury. Thank you.
Okay, thank you both. That concludes our oral argument in this case. We will be in recess and deliberate, and everything's under advisement. All right,
Thank
have a
you.
good day. Thank you, counsel.
Thank you.
Thank you, Your Honor.
Thank you very
All right,
much.
I'm going to call you then.